SJC-12580, Daniel D. Tavares v. Commonwealth.
Good morning, Mr. Tavares. You have 10 minutes.
If it pleases the court, Your Honors, I have a police report here where there was a photo lineup and the actual victim identified someone else. And they've been holding this back from you guys the whole time. Okay, and I'd like to submit it into evidence because my fiance just found it Friday. They would not give it to me at Barnstable District Court. My lawyers wouldn't give it to me. I could not obtain it. Okay, there was a photo lineup, and he picked somebody else, not me. And I'd like to submit it into the court. I'd like to make an open court motion to submit this into evidence.
You may submit it, but we don't take evidence. It may be submitted as a filing.
Yes, sir, Your Honor.
But if it is to be evidence, you would have to submit it as part of a motion for new trial in the court for which you were convicted. So we're here simply to determine whether or not there's an adequate alternative remedy for you. So, but in any event, Mr. Keneally may take it, may note its receipt, but just to caution you, we're not a court which newly
Yes,
takes
sir, Your Honor.
evidence. You'd have to go back to the Superior Court where you were convicted and present that as part of a motion for new trial.
Yes, okay. My argument today, Your Honor, is double jeopardy. Okay, that's what I'm arguing. The Commonwealth submitted their brief claiming that I'm allegedly claiming ineffective assistance of counsel. That's not my argument. My argument is double jeopardy. I put it in my original brief to the single justice, Your Honor. I argue in the single justice motion that the convictions for uttering and larceny were duplicative. Double jeopardy, and that's my argument. Court has any questions? That's my argument, Your Honor, double jeopardy. If the court has any questions for me, that's fine. Be glad to answer them. With that, I rest.
Okay, thank you. Ms. Carey, you wish to be heard?
Good morning. May it please the court. The single justice properly denied the defendant's motion where the defendant has not brought this before the trial court. This is something that would be most properly brought before as a motion for a new trial.
So what is the status of the case right now? He was convicted in the Superior Court.
So he was convicted. There was an appeal, 14P190. In that appeal, he raised insufficiency of the evidence with regard to his identity as the individual who passed the note at the gas station, and then he raised an insufficiency of the evidence with regard to his knowledge that the bills were essentially fakes. That appeal was denied, FAR denied, and then a subsequent appeal to that, there was a motion for jail credit. This was also denied. At that point, or at a later point, there was a civil action for wrongful conviction. That was denied and ultimately dismissed for failure to state a claim upon which relief could be granted, ultimately because he hadn't demonstrated that the underlying conviction had been flipped, essentially. And so that left us with, he came forward with his 211-3, which my interpretation was two claims of ineffective assistance of counsel, one at the trial level and one at the appellate level, and that also the jury was lied to, which my interpretation was that there would be some claim of error in the jury instructions. These having not been presented as a motion for new trial were not essentially ripe yet to be before the court. And ultimately, the 211-3 was denied, and he was instructed in that opinion to take further action at the trial court level, which I would argue is appropriate with a motion for new trial.
So your argument is that if he were to have a remedy, and you certainly are not conceding that he does, the only remedy would be to file a motion for new trial in the Superior Court where he was convicted.
Yes.
Okay, thank
If there
you.
are no further questions, I'll rest on my brief. Thank you.